When self-defense becomes a crime. Listen, what I'm about to tell you is going to make your blood boil, but stick with me because this story has a twist ending that's going to restore your faith in the Second Amendment community, and it's all thanks to something most people blame for dividing us: social media. A woman, valid concealed carry permit, lawful gun owner, viciously attacked on a Maryland highway. She defended herself without even firing a shot. And guess who got arrested? Not the attacker, her. But here's where it gets incredible. A case that was dead in the water, a pro-SC petition that nobody in the legal world had even heard of, just got picked up by the biggest names in Second Amendment litigation. The NRA, the Second Amendment Foundation, 24 state attorneys general, even United States senators. How did that happen? I'll tell you exactly how, and why this case could change everything for gun owners who travel across state lines. But before that, please subscribe to our channel and let's dive into Gardner vs. Maryland, the coolest Second Amendment news you'll hear all week. Section 1. The power of social media done right. For a lot of people, social media feels like more trouble than it's worth. It's blamed for misinformation, polarization, and endless noise, and in many cases, that criticism is fair. But when it comes to constitutional advocacy, especially in the Second Amendment space, social media has quietly become one of the most powerful tools available, not because it's flashy, but because it connects people who would otherwise never find each other. When used responsibly, it turns isolated legal injustices into national conversations. What critics often miss is that social media doesn't create movements on its own. People do. When informed individuals share accurate information and focus on real cases instead of outrage, social platforms can amplify truth faster than any press release or traditional campaign ever could. That shift has completely changed how Second Amendment litigation works today. Key points to understand. Before social media, individual gun owners facing unconstitutional charges were usually alone. Legal cases rarely gained attention unless major organizations were already involved. Most injustices stayed local and quietly ended without broader scrutiny. Social media now allows compelling, fact-based cases to gain national visibility. It creates a direct pipeline between affected individuals and legal advocacy groups. What happened in Gardner versus Maryland is a textbook example of this shift. One online mention led to researchers, attorneys, and national organizations discovering a case that otherwise would have disappeared. Within weeks, a lone pro-SC petitioner gained serious legal backing and national support. That kind of mobilization simply did not exist 20 years ago. This is what social media looks like when it's used correctly, and frankly, it's something the Second Amendment community needs more of. Section 2. How this case came to light. This case didn't surface through headlines or press conferences. It appeared quietly, almost accidentally, buried among hundreds of other petitions headed toward a Supreme Court conference. At first glance, it looked like just another case destined for denial, the kind that never makes it past the initial review stage. And statistically, that assumption made sense. Every year, the Supreme Court receives thousands of petitions for certiorari and accepts only a tiny fraction of them. The odds are so low that most cases are effectively over before they begin. That's why this one stood out, not because of its visibility, but because of how unusual it was once you actually looked at it. What immediately raised red flags? The case was unfamiliar even to people who closely track Second Amendment litigation. The petition did not follow the polished format of major law firm filings. Legal citations were imperfect but earnest. The writing was clear but lacked professional legal styling. It quickly became apparent the petitioner was representing herself. Pro-C petitions almost never succeed at the Supreme Court level, and that reality alone usually ends the conversation. But once the facts came into focus, everything changed. This wasn't a weak or messy case. It was the opposite. It was clean, emotionally compelling, and legally precise in a way most cases never are. What initially looked like a dead case turned out to be something entirely different. A rare example of facts lining up perfectly with constitutional doctrine. Section 3. A fact pattern courts can't ignore. To understand why this case matters, you have to understand how clean the facts are. Eva Marie Gardner is not a fringe plaintiff. She is a lawful gun owner with a valid concealed carry permit from her home state of Virginia. She has no criminal history and no behavior prosecutors can spin to distract from the core legal issue. She represents exactly the kind of citizen the Second Amendment is meant to protect. The incident itself unfolded on a major interstate highway, not a secluded or suspicious setting. While traveling through Maryland, Gardner was intentionally forced off the road by an aggressive driver. This was a violent act that could have easily resulted in serious injury or death. When the attacker exited his vehicle and advanced toward her, Gardner did what countless law-abiding citizens are trained to do. She displayed her firearm without firing, threatening, or escalating further. Why these facts are so powerful? The plaintiff was lawfully armed in her home state. She was the victim of an unprovoked, violent attack. She displayed her firearm defensively without firing a shot. The situation immediately de-escalated without injury. Police arrested her instead of the aggressor. The charge had nothing to do with misuse of a firearm. Gardner was arrested solely for possessing a firearm in Maryland without a Maryland-issued permit. Her Virginia permit didn't matter. The defensive nature of her actions didn't matter. Even the fact that she was traveling on a federal highway didn't matter. This is exactly the kind of case courts rarely get, one where the legal question is clean and the equities overwhelmingly favor the citizen. That's why this fact pattern is so dangerous to states like Maryland. Section 4. Maryland's Constitutional Trap. Maryland didn't just enforce a restrictive law, it enforced an impossible one. At the time of Gardner's arrest, the state operated under a may-issue concealed carry system, meaning permits were granted at the discretion of government officials rather than based on objective criteria. Even qualified applicants could be denied simply because a bureaucrat decided their reason for carrying wasn't good enough. For out-of-state residents, the problem was even worse. Maryland required 16 hours of training at state-approved facilities, training that had to be completed in Maryland itself. That meant Gardner would have needed to travel into the very state where carrying was illegal for her, complete redundant training, pay significant fees, and still face denial. Why compliance was effectively impossible? Maryland required a subjective, good and substantial reason. General self-defense concerns were not sufficient. Training had to be completed at Maryland-approved locations. Out-of-state permits were completely ignored. Maryland had zero reciprocity with any other state. Maryland is the only state in the country with no permit reciprocity at all. That means a lawful gun owner can travel freely through nearly every state without becoming a felon, except Maryland. The state's position effectively forces people to disarm while traveling or risk arrest, even when passing through on major interstate highways. Section 5. The Social Media Miracle. What happened next shows the quiet power of the internet. On November 21st, someone briefly mentioned Gardner versus Maryland online. Casas Moros from the Second Amendment Foundation saw it and something clicked. He'd never heard of the case but decided to investigate. He pulled the petition, read through the facts, and studied Maryland's laws. It didn't take long to realize two things. Gardner got steamrolled by an unconstitutional system, and the case was a perfect vehicle for review. What followed changed everything. Casas pushed the Second Amendment Foundation to support Gardner. They filed an official amicus brief with the Supreme Court. Then they launched a media push, social posts, email lists, outreach. Other gun rights groups saw it and began researching the case. Suddenly, Gardner had serious legal support and momentum. What began as a lone pro-SC petition was now snowballing. Gardner got real counsel. Experienced 2A litigators, and more groups joined in. Briefs started flooding the docket from the NRA, CRPA, SAF, and others. Then came the Cato Institute, the Heller Foundation, and 24 state attorneys general. Even sitting U.S. senators filed a joint brief. That level of backing is nearly unheard of for a case that no one knew existed a month earlier. It proves that when the right case meets the right message, community action can change everything, even at the Supreme Court level. Section 6. The 24-State Showdown. What turned heads at the Supreme Court wasn't just one woman's case, it was the backing of nearly half the country. 24 state attorneys general stepped forward with a powerful message. This isn't just about Maryland. It's about a growing threat to every American's constitutional rights when they cross state lines. Their amicus brief warned that Maryland's actions could set a dangerous precedent for all 50 states. They emphasized that states are overstepping by criminalizing constitutional rights of out-of-state citizens. Key concern: Maryland is a major corridor many Americans must travel through it routinely. The brief stressed that when states joined the Union, they agreed to uphold the full Constitution. They argued Maryland's law violates core federalism by refusing to honor rights protected nationwide. This is more than a Second Amendment issue. It's a test of whether states can nullify constitutional protections for people from other states. Virginia and New Hampshire, both strong pro-2A states, made it clear, if this stands, no gun owner is safe from legal traps just for traveling. That's why this case may shape gun rights for generations. Section 7. Senators join the fight. When U.S. senators start weighing in on a Supreme Court petition, it means the stakes are sky high. Led by Senator Ted Cruz, a group of lawmakers submitted their own brief, and their message was loud and clear. Constitutional rights don't stop at the state border. Senators argued the Second Amendment should be treated like every other right fully portable across states. They warned Maryland's refusal to honor out-of-state permits creates a patchwork that violates equal protection. They pointed to other rights, free speech, due process which don't disappear when you cross state lines. The brief referenced the Concealed Carry Reciprocity Act, showing Congress is trying to fix this nationwide. Lawmakers called on the court to act now, since legislative solutions have stalled in gridlock. The senator's position echoed what millions of gun owners have said for years. The right to bear arms is not conditional on geography. When states defy that principle, it's the court's job to step in. This petition gives the justices a chance to finally say, once and for all, that the Constitution travels with you. Section 8. The power of a perfect case. The Gardner case didn't just gain traction because of noise or outrage. It gained momentum because the facts are clean, the law is overreaching, and the constitutional question is razor sharp. It's the kind of case lawyers dream about when challenging unjust laws. Gardner had a valid carry permit from another state and was arrested simply for crossing into Maryland. She had no criminal intent, no dangerous behavior, and followed all other applicable laws. Maryland's law criminalized her merely for possessing a handgun, despite her being otherwise eligible to carry. No violence occurred, no public safety threat, no prior convictions, just paperwork mismatch. The punishment: years in prison, a permanent criminal record, and loss of rights. These facts don't allow the government to hide behind complexity. There's no gray area. It's a head-on collision between constitutional rights and a state law that refuses to respect them. And that clarity is why the court may be willing to act. Section 9. The real-world consequences. While the court delays, real people are paying the price. Across the country, law-abiding gun owners face felony charges simply for traveling between states. Their lives are turned upside down not because they committed a violent act, but because one state refuses to recognize another's permit. Drivers are arrested during traffic stops for having a handgun they could legally carry back home. Veterans and retirees are charged while visiting family in restrictive states. Women with concealed carry permits for self-defense are prosecuted in unfamiliar jurisdictions. Travelers are detained at airports and rest stops over locked firearms in their luggage. Entire livelihoods are lost over misunderstandings, not malice. This isn't theoretical. These are working Americans who end up in court, lose jobs, and face jail for crossing an invisible line. The promise of the Second Amendment is being selectively enforced, and the clock is ticking for the court to fix that. Section 10. Will SCOTUS finally act? The Supreme Court has all the ingredients: a clean case, massive public interest, and growing legal support. The only question now is whether they'll grant cert, that is, agree to hear the case. The petition is on their desk, and they've rescheduled it more than once. The growing stack of amicus briefs signals mounting national pressure. Major precedent like Bruin and McDonald has already laid the groundwork. Federal courts remain deeply divided, causing legal chaos from state to state. If SCOTUS denies review, it may signal further delay for nationwide 2A clarity. Everyone from civil rights attorneys to everyday permit holders is watching. The moment for a nationwide concealed carry ruling may be here. And if Gardner versus Maryland is the case to make it happen, the time for the court to act is now. The next move is ours. The court has the facts, the filings, and the firepower behind this case. But until they act, the burden still falls on us to stay informed, to speak up, and to support those fighting these battles on the front lines. Because one case can change the landscape for millions, and Gardner versus Maryland just might be that case. If you found this breakdown helpful, make sure to subscribe so you don't miss what happens next. The future of your rights may depend on it.